a hearing, an evidentiary hearing, to determine whether or not there is water available, and then you're finding them by the day, that's a huge problem. And it's one that's definitely going to lead to significant litigation in the area. And on that note, I'd also like to echo Mr. Nomlini's comments that if you think that this process through the emergency regulations is going to be any more expedient than the current process you already have, you are significantly mistaken, because you will be getting your a large volume of petitions for reconsideration at a very rapid pace, and you will not be able to expedite all of them, and it will be a very lengthy process. In closing, the last serious drought that we had was in 1977. It certainly preceded myself. What has this board done to prepare for a serious drought in the past 30 years? Absolutely nothing. And then we're here today considering an emergency regulation to curtail farmers who depend on it in reaction to an emergency drought that you've done nothing to prepare for. This has been a shortcoming of the state board and the state water system in and of itself. And we're paying the price for it, and that's not acceptable to us. And we would urge this board to oppose the adoption of the emergency regulations today. Thank you.
Jasbir Nihar, please tell me how to pronounce it, and then John Rubin.
It's Jasbir Nidger.
Oh,
Thank you.
okay.
I'm a grower in the Patterson area, and I have land in Patterson Irrigation District, West Stanislaus Irrigation District, and West Side Irrigation District. I know there's been some talk. I just heard the gentleman mention that almonds are not going extinct. That's probably the case. They won't be going extinct, but we sure are hurting. And I brought some pictures with me, and I don't need to show it to the farm folks. I'll just point it to the board. You know, you can see a healthy tree here in the back, and see what that looks like. And you can see these are trees that have been already affected by post-1914 curtailment. So the curtailment is already in place, and the trees are receiving a lot less water, less than 50% of what they normally would receive. So now they're picking up the salt. They're hitting the salt layer, which they normally would not hit because the roots are going deeper, try to get the water, and this is doing permanent damage to the crop. Not just this year. This year's going to be minimal because crop is already there. It's going to be the next 3 years coming up, and so no, they're not extinct, but we sure are hurting. So that's point one. But that's not my main point. I think there's a bigger point that we're not really talking about, nobody's really talked about here, which is how is this going to affect water availability in the next 2 decades? You guys, the board knows that agriculture is the biggest human user of water. 40%, and in cities are 10%. The other 50% going to the environment and keeping things flowing. And numbers may be off by 1% here or there, but those are rough numbers. So of human activity, we are 80% the user. Okay, and why is that significant? Because when you're burning up these orchards, you're saying, well, that's great. We'll have less orchards. These orchards use less water than open ground. And like vineyards, they will use maybe 50% of the water you would use on tomatoes and alfalfa or these kind of other crops. Right now, California has been on a path, it's like a marching path to go from open ground to permanent plantings, and that's been great for the economy. With the open crops, the workers are getting paid more. There's more dollars to play with. There's more taxes to pay, and more importantly, we use less water. Okay, a lot less water, even from 30 to 50% less. And you know what's happening right now? I'm taking a $300,000 hit because I'm trying to put in 2 wells, which sadly will not be in place to prevent this damage. Probably going to be sometime late in the year. And I'm putting it as a safety for next year. I'm taking about $400,000 hit. I'm a small farmer, 240 acres. I'm not, a corporate farmer here, or I'm a family farmer. I do my own work. I have one employee. I sometimes have part-time employees, but I'm taking another $400,000 hit, most likely between a little bit of this year and mostly next year. $400,000 hit on my revenues. That's $700,000 for a family farmer. Okay, it was well, Judge, that sucks for you, but what does that do with us in the water, right? Well, guess what? I had 40 acres. I have open land, which I was planning to develop into a permanent planting. That's not going to happen. Okay, I was planning another 100 acres. I wanted to lease and put into permanent planting. That's not going to happen because, and the banks, they're circling us. They're circling us, and where you don't have water, they're looking at our operating loans and saying, well, do we want to renew those loans? So we're fighting to keep what we have. Forget about expanding. And we're 80% of the human use in the state of California, and we are Californians. I know there's a few bad apples in the farming community. There's a few, Chair, there's a few. But a lot of us, we care about California. We care about water use. We want to have it available for long term. We're not like, okay, well, screw the water board and I do what I want, right? So what I'm saying is, if you do additional curtailments, it's going to hurt you more. I got land there pre-1914 as well. And the more you hurt us with these curtailments and saving these waters and reservoirs, over the next 2 decades, you're going to have less water in those reservoirs because more of that land's going to be open. It's going to be planting stuff that's taking a lot of water. You got to take that into consideration. Don't just look at this year, next year. Look at the next 2 decades. I understand there's a water bond going on. I understand all those things.
No, all of it is just, I don't mean to cut you off, I'm just mindful of the other people who are here. I mean, what we're trying to do here, whether we've hit it or not, and that will be a discussion that we have when the speakers have ended, is really a well-intended attempt to try and implement the Water Code of California, which is heavily seniority based. And today we're talking exclusively about seniors versus less senior. And that's just the nature of this effort. It is not a judgment on agriculture versus anything else at all. I think if you knew us, you would realize how supportive of agriculture we are. But we're charged with figuring out how to protect the seniority rights of water, and we're intending to do that. I just want you to know that's what we're trying to figure out. We're not trying to cast aspersions on...
Sure.
We're not trying to hurt agriculture. We're trying to figure out how to...
I honestly believe you're not trying to hurt us. That's
yeah,
for sure.
we're trying to figure out how to implement our responsibilities, and it's challenging, obviously. And then if you could wrap up, just because
sure.
there are other
I'm
people.
sorry. Give me one more minute, please. So in conclusion, I really want to emphasize, if you care about the environment, which I do, I consider myself an environmentalist, just as much as a farmer. If you really care about the environment, please do not do any additional curtailments. It's going to take financing away from us. It takes money to reduce water usage. I can have good intentions, but it costs, on 100 acres, it costs $250,000 to put in a micro irrigation sprinkler system. And when there's like these kind of threats, okay, there's $2,500 an acre, the banks don't want to do financing. Okay, so please, if you care about the environment, if you care about reducing water usage long term, agriculture is 80% of the water usage. Okay, if we can do 20% in agriculture over the next 10 years, that's going to have a huge impact on the water availability for all users, environmental, for cities, for everyone, okay? That's my final point. Thank you for your consideration.
Thank you, sir. John Rubin, followed by Philip Williams.
Good afternoon, Madam Chair, Madam Vice Chair, members of the board. My name is John Rubin. I'm General Counsel for the San Luis and Delta Mendota Water Authority. I'll be raising three, hopefully very concise points today. First, I want to reiterate a point that I made at the workshop on May 20th, and that is the Water Authority believes that there is a clear need for water users to stop diverting, certain water users to stop diverting, because there's insufficient water available under those diverters' priority of right. The need to stop diverting when there's insufficient water under the right is threefold. First, it's important to protect previously stored water. Central Valley Project, State Water Project, water. Second, it's important to protect investments that have been made in transfers and exchanges. These are critical tools. You haven't heard a lot about this today, but transfers and exchanges are critical tools that are being used this year. If diversions continue that are not supported under the priority of right system, there's additional, essentially, tax that's imposed on transfers. And those taxes are generally high. If the diversions continue without reduction, those taxes go up even higher. And then third, it's important to protect the seniority principles, the senior water rights. Now, with that said, the Water Authority does not take a position on how those diversions should cease. The second point that I would like to make is regarding kind of implementation, how those diversions may stop. Whether they're through emergency regulation or any other means, it's just a daunting, very challenging task. I do want to note that there are some areas that make the job easier and qualified. It's relative. But I do want to point out, as I did on the 20th, a statement and findings that this board made in Decision 1641. And I cite page 33 of Decision 1641, where the board recognized that Southern Delta riparian right holders have no right to water from the Sacramento River. It's a finding that was made after an adjudicatory proceeding, a hearing, and significant deliberation by the board. And second, this is a summary of findings, but insufficient water is available in July during 16% of the years, in August during 56% of the years, in September during 78% of the years, and October during 70% of the years. This finding is that there's insufficient water in the South Delta to support riparian diversions. And given the type of hydrology this year, a question will be whether this year falls within those types of percentages where there's insufficient water. My point here is that you have statements, you have findings that have been made that will help narrow the question and make some of these challenges a little bit easier. Now, with that said, I do want to highlight an area where there is a challenge. The Water Authority has been working with other water users to try to improve the certainty of water rights in the South Delta. We've been doing this for a number of years. Unfortunately, those efforts have not been successful, at least at this point. One way that could have been cured is through the statements of diversion and use that are now required under the 2009 Delta Reform Act. The State Board adopted guidelines, has a form for those statements. The guidelines were adopted in 2011. Unfortunately, those guidelines and the statements that have been filed are going to present a challenge for the staff or for those that are seeking to curtail diversions. I went through and looked at some in Old River. I pulled 20, and what I found were, of the 20 statements of diversion and use that I was looking at, they all had the exact same priority date. They all claimed pre-14 and riparian water use at a minimum. They all appeared to be following a very similar format in terms of response, and that's going to present a real challenge for you. And so I note this may not be helpful that you have this challenge. I tried to explain where there's areas where you can kind of focus, but this leads to a recommendation, two specific recommendations.
And then try and be quick.
Yes.
Sorry.
First recommendation is, as the deputy director develops information, if you adopt the regulations today or tomorrow or in the future, if the deputy director is developing information, there should be a process where interested parties can assist the deputy director or a designee, making sure that the breadth of information is accurate, that you have the full data that's available, as well as the deputy director or the designee understanding where there's gaps or uncertainty with the information that she's reviewing. And then my last comment, a very technical comment. There's a provision in the regulations. This is under section 875C1 that states, absent evidence to the contrary, riparian water rights are presumed senior to appropriative water rights for purposes of curtailments pursuant to this section. I think that's a very gross statement and could lead to action that is inconsistent with the law. Riparian water right holders, I think this is a fairly well-accepted principle. Riparian water right holders have a priority over appropriators to natural flow. This statement is not limited in that fashion. And so what I would recommend is either the statement be removed or the statement be revised to reflect the law, and therefore the riparians are going to be presumed to have a priority over appropriators to natural flow. Thank you.
Thank you, Mr. Riven. Mr. Williams, and then Joseph Ray from PG&E.
Good afternoon, Madam Chair, members of the board. Good afternoon. My name is Philip A. Williams. I'm the Deputy General Counsel at Westlands Water District. Westlands Water District supports passing the emergency regulations precisely because we are in a state of emergency. And emergency regulations are therefore appropriate and entirely under your authority, vested by the legislature in SB 104 at Water Code 1058.5. The people of the state have spoken very clearly about the duties and responsibilities before you. Now, that being said, we are in a state of emergency. And with all due respect, we are not in a state of intermediacy. And we would argue that intermediacy is what brought a grandfather in front of this board concerned about the future of his grandson. And it's what brought a young man in front of this board concerned about the future and providing for his family. Intermediate steps are what brought us here. The question before this board is, how many more grandparents, how many more young men are going to come before you? Because we took intermediate steps and we didn't recognize the exigency of the situation in front of us. By mid-July, the reality is that there will be less than 200 CFS flowing down Vernalis. The data show that there's insufficient flow to support existing diversions. These conditions present enormous challenges to everyone. If the state board fails to act in these circumstances, it will send a message that not only is our system of water rights broken, but that the institution responsible for the orderly administration of that system cannot carry out its duty. Any notion that no one is being harmed under the existing system is pure fiction. Westlands farmers, their families, and the communities they live in are already suffering under a crushing 0% allocation. Any loss of stored project water, any loss of transfer water floating through the system amounts to a significant and measurable impact to those communities and those people. This year, our farmers are relying extensively on transfers. We have contracted for 60,000 acre-feet that will have to travel through the system. Generally, we plan for a 20% carriage loss. This year, carriage losses are estimated at 30%, 10% increase, increased depletions. That increase expresses itself in 6,000 acre-feet of water. In monetary terms, direct monetary terms that our farmers paid, that's over $2 million. Land put out of production, that's 2,400 acres. If you use almonds for revenue, that's over $21 million, just in the transfer, just in a 10% increase in depletions. Additionally, the fact that ZVP water has been backstopping illegal diversions has to cease. Faults in a system don't begin to express themselves until the system is stressed. Everything's working even if it's not working very well while everything's working. Suddenly things stop working and everything starts bubbling to the top. Though the illegal diversions have been something we have repeatedly brought before this board, it's only now becoming evident to everyone else that there's a problem happening somewhere in the system. We ought to take a step back and ask ourselves a very hard question of exactly how much, with 3 years of very little rain, just how much natural flow is flowing in our rivers, just how much natural flow is floating in our sloughs in the Delta. And that's a hard question, but it's one that we have to ask. The emergency regulations are a proper exercise of this body's authority. Yes, ma'am. You have the authority. You have the authority to regulate and curtail pre-1914 appropriators and riparians. You have that authority. And the regulations afford everyone due process and don't deny anyone the right to divert water that they are actually entitled to divert. Finally, Member D'Adamo, you had asked for tools. We can only suggest two. The first one being, we recommend if you take stored water and transfer water out as variables out of the calculus, that though painful, it will put this board and this state on the right path to finally nailing down our water rights system. And finally, the second board, and I say with all due respect and all due sensitivity to your position, because you have a fight coming, and you couldn't pay me enough to be sitting where you are sitting. The tools I would give you, courage and fortitude. Thank you for your time.
Thank you. Joseph Ray, followed by Valerie Kincaid.
Good afternoon, Chairman, members of the board. My name is Joseph Ray. I'm the water rights engineer for Pacific Gas and Electric Company. I want to discuss storage rights. PG&E operates 68 powerhouses. We use the water as it comes down the hill. We generate electricity from it. We return the water to the stream. All the water we divert is available downstream. We also, under our direct diversion rights, there's no question that we have an exemption. On the storage rights, is a little. We receive conflicting advice, depending on who we talk to, on whether or not they need to be curtailed. We have two different kinds of storage rights. There's typical storage. Our reservoirs are pretty small for the most part, where starting in October 1st, our reservoir is very low. We have only enough we don't do year-to-year carryover. We have enough to meet our minimum in-stream flows. In the wintertime, it'll start to fill up, and then when the snow melts in the spring, that's when we really fill up our reservoirs. And then as you come to the summertime, we start releasing it. When flows are low in the river, we release the water. All the water we release from our reservoirs passes through the powerhouses and is available downstream. Right now, for example, as we're in the middle of the drought, we're releasing water. We'll probably release close to 1 million acre-feet of water that was stored in the springtime that's going to be available to help with the drought situation. We also have what are called regulatory reservoirs, and this is the main part of what I want to discuss. As opposed to the sine curve you'd see on a hydrograph for our storage reservoirs, our regulatory reservoirs, our forebays, afterbays, and regulators, are flat. If you were to look at the hydrograph, it would look kind of like a saw, the edge of a saw blade. We operate those reservoirs almost full, up around 90% full, and then it'll go up and down 2 or 3% to follow daily loads. What that allows us to do is when there's insufficient flow to run the powerhouse at full speed, we can run the powerhouse at a higher rate during the peak hours. You heard earlier this morning the CEC and Cal ISO talk about they have enough resources, but it's the emergencies, it's the peaks that you need to meet, and that's what we do with those regulatory reservoirs. The water we're talking about is a couple hours worth of water, so we'll operate a little bit higher. The level of that reservoir will go up and down literally a few percent in a day or over a 2-day period. So those reservoirs do not store water. They're just attenuating the flow, and the afterbays are smoothing out the releases into the river. We would recommend and we would advise that our regulatory reservoirs should be exempt from any curtailment. If they're not, they take away the ability to follow load, the electric load, and it supplies no additional water downstream. So there's no water benefit going downstream, but there is a impact on our operation of our powerhouses. If there's any questions, I'd be happy to answer them.
That's great. And you have been talking with our staff about this?
Various members, yes.
Madam Chair, if I could just add, we've been in conversations with PG&E, and I believe we sent a clarifying email last week, and it may not have made it through everyone, but it was sent to Alvin Toma, indicating that the non-consumptive power component of the notices covers the regulating reservoirs. So I believe we've addressed that issue.
Okay, like I said, we've gotten different comments from staff, and what I'll do then is I'll send you an email. If we get confirmation out, we'd appreciate it.
Yeah, I will forward that email to you.
Thank you.
Thank you. All right, Valerie Kincaid, followed by Dan Kelly. Hello.
Good afternoon, Board. Valerie Kincaid for Oakdale Irrigation District and San Joaquin Tributaries Authority. It's late in the day, and a lot of the points that I have already been made, and we made them in our written comments for the SJTA as well, so I'll be brief. The first issue is transparency. I read the proposed amendment and certainly do not think it is sufficient. In the SJTA written comments, we provided proposed amendment to the regulation, and we certainly think that's more appropriate information that's necessary upon which to base a curtailment. So we would urge the board to adopt something more in line with that than the proposed amendment by staff this morning. The second is that we certainly support Mr. Lilly's suggestion earlier about ending curtailment or lifting curtailment if it is not ended around September 30th when the fall potentially rainy season comes. I certainly don't think it's your intent to cut off people from diverting water to storage, so that can be addressed either through really good process language or probably more simply by Mr. Lilly's suggestion. My third point is based on Ms. Zalezi's interaction and comments with the board, and I know that this is a point that's been hit, but for my clarification, it would really help for me to understand the process, and I think if I can make a quick comment and then maybe have a staff interaction or answer from it, it'd be really helpful. I find a lot of the confusion with the process is due to a potential CDO, and then this, I think what I understand to be a secondary enforcement action, which is a violation of the curtailment order. So I guess for me, it would be really helpful to understand if either, or if you can do a petition for reconsideration on either or both of those, and for staff to explain which one of those in either, both, or neither can you provide information about, or can you challenge and present evidence regarding availability and priority?
Go ahead. Question?
So I think the first response is that the petition for reconsideration process is available for any order. So that would include a curtailment order and, as already exists, an administrative civil liability order or a cease and desist order. So certainly all existing available processes remain available. That includes a petition for reconsideration process for existing enforcement processes, as well as we've discussed already, the petition for reconsideration process for the curtailment order. What was the second part of your question?
So that's helpful. And so the CDO process, it sounds like, is the more traditional process, and it doesn't start with the curtailment order necessarily. So when you have a curtailment order that you've been issued, and you can do petition for reconsideration against that order, are you at that time able to provide evidence? And is it on the table? Is the availability analysis and seniority on the table at that point? My understanding previously is that to challenge a curtailment order, you could do a petition for reconsideration, but none of those issues are on the table. It's just more of a whether you violated the order, whether you continue to divert or not. Is that right?
The scope of evidence that you'd be dealing with for whether you violated the order would be if there's subsequent enforcement. In a petition for reconsideration for a curtailment order, I think that would be the exact issue you'd want to be addressing, is whether there is water available for your priority.
Okay, great. That's helpful for me. I guess I was thinking of it as there was a traditional CDO process that would come after a curtailment order, but that you would not be allowed to bring into evidence in a petition for reconsideration on a curtailment order your availability analysis and priority. So if certainly the way the regs are written, as I read them, that process is not made clear. So I would certainly recommend that if that is the process that is understood, which is that you can do a petition for reconsideration for either of those, and in both of those situations you are actually able to present evidence of availability and challenge the availability analysis and challenge the priority analysis, I think that certainly needs to be clarified.
Let me be clear, I didn't say that in both of those processes you'd be able to challenge the water availability analysis. That would be sort of two bites at the apple. You challenge the water availability analysis in challenging the curtailment order, which addresses the water availability in the first instance. So the process, as it would be outlined by the regulation, would be that a curtailment order is issued, and the curtailment order would address availability of water for the diverter based on all the information that's provided in the regulation. Petition for reconsideration process is available based on that order, and the challenge would be to the basis for that order, which is whether water is available to that diverter. Once that process has completely run, no, I don't think it would be accurate to say that in subsequent enforcement, challenging that those determinations would be available again.
But
So what evidence? Okay. So can we revise it to make that clear, and also to make clear what evidence and what you'd be challenging in a subsequent CDO if that existed? Because that's unclear to me. I don't know what evidence you would put forward if you couldn't question availability and
if the board
seniority.
If the board took a CDO action after all of the process had run for petition for reconsideration on the curtailment order, then there would be two potential bases for the CDO. One would be unauthorized diversion if that were pursued under 1052, and then the question of whether there's an unauthorized diversion would be subject to challenge and evidence. If the board is pursuing a cease and desist order based on the violation of the regulation, those questions would have already been answered, and whether cease and desist orders should be issued based on the facts that are already in the record would be the question before the board on the cease and desist order under those circumstances.
Okay,
and
that's helpful.
when would those questions have already been answered?
In the petition for reconsideration process on the curtailment order. So the new process that's created under the regulation for challenging, petitioning for reconsideration of the curtailment order, the entire purpose of petitioning for reconsideration is just taking a shot in the dark. Somebody might disagree with the curtailment order, and if they did, then they would challenge the basis for that order. So the entire process would run, I'm assuming, I don't think there would be much overlap, I would hope, between an enforcement process and the petition for reconsideration process, but the petition for reconsideration process is the due process for determining the availability of water.
Yeah,
And then the
one-
enforcement on the CDO would be a question of whether or not someone curtailed in compliance with the order, but that would all be
Correct. If the board
after the,
chose to pursue a cease and desist order based on the outcome of having done the curtailment order, somebody continues to divert, and the board felt it was necessary to again tell them to cease and desist, because the initial curtailment order, I don't want to call it a cease and desist order because that's a specific term, but it is an order that, akin to a cease and desist order, immediately tells the diverter that they need to stop their
would
diversion.
be, according to our information, there's no water for you.
So, exactly. The
Yeah.
curtailment order is very similar to the,
Okay, and so that's a finding at a certain point in time. What hasn't been discussed so far is what precedes that. In other words, there's a notice of curtailment, and then there's an opportunity at that point to refine the issues of availability of water, the assumption of the date, quantity, and all that. No. There's a notice, there's a curtailment notice.
not under
There
the
should be.
emergency
You are
regulation
correct about that.
process. Under the current.
No, this is important, because this gets back to process in terms of communicating the basis for the action and not dropping a notice in the mail all of a sudden. That's just not practical. So you need to help me then, because a curtailment order before an opportunity, to provide information and to refine it. I'm now, because we issued curtailment notices.
I think you've hit upon why I asked for intermediary steps before the actual.
Well, yes, but okay, all right, if I'm getting it wrong, I accept that. But for instance, we issued the letters in late May, okay? That was a notice to junior post-14 water right, okay? At that, don't they have an opportunity to furnish you information prior to issuing an order? Or us issuing an order?
They do, but not an evidentiary hearing.
And
Okay.
that's not pursuant to the emergency regs. So you're exactly right. That is the process that exists outside these regulations.
But I wasn't saying evidentiary
Yeah.
hearing. I was talking more about this, a little more informal, you know, in terms of a meeting, technical sharing of information, you know, in the spirit of being efficient, getting that information right before the staff draft a curtailment order. I mean, we have
Well, people
something
have been
similar.
calling in.
And that's one of the
Pretty
things that
well.
we've heard, and as Tam had mentioned, maybe we need something a little bit more in the process in terms of that notice, or at least here's the information that we have on our website. But this really gets at the crux of what an advantage, if you will, depending on your perspective here, because we've been hearing a lot about the due process, is that just one time, rather than water right by water right, having to go through that due process and finding that water availability, rather it's like, here is the curtailment order. Where we're doing this once, because there's enough similarity, we tend to focus oftentimes on, here are all the differences, here's this detail, but there's going to be large classes where we have information for a large enough area, a large enough class, that a curtailment order can be used and would be appropriate, and then we respond to any of the concerns about, well, there is too water available, and there really isn't under this broad order in this broad class, and we do that through the response petition for reconsideration once as part of that due process, but certainly not as part of necessarily an evidentiary hearing.
Right, but one of the issues that's been raised, and we'll get to this, I'm trying to get through all the comments before we group the potential actions or directions to you, because everyone who's come up has had something of value to flag, whether it's a misperception, a real perception, a real problem. We're trying to figure out how to deal with it. On the petitions for reconsideration, I mean, are you envisioning, because we haven't said specifically, that we would group them all and do one big hearing on a bucket or a stretch, or that we would do individual options for a hearing one by one? That was my question earlier, because what we're trying to do, you know, you're obviously hearing a concern that people want to understand the basis for what we do. They want it to be more transparent. This is something that affects them if they feel they're on the bubble or that we've got it wrong. And right now we have a process in here that makes it discretionary for us to review, and some people are they're worried about that we won't. So when you say we'd handle it in the petitions for reconsideration, you mean one by one? You mean we could group them? Would we have the flexibility of doing it in different ways? What do you envision?
I think we have the flexibility to do it in different ways, but generally a grouping, because I think we would generally find the same fact pattern, though many might say, well, there is water available. Well, if we're looking at some particular reach, some particular area that has the certain flows, it would be applicable to all for, again,
Similarly
once we determine what that cutoff is in terms of the priority date. So yes, they can be lumped in that way.
I think the
But
goal
there-
would be certainly to respond to every petition for reconsideration, but if the board were to hold an evidentiary hearing, for example, the board may choose to address a group of people and notice each of them individually so that they know that the hearing on common issues is going to provide each of them the opportunity to speak, and then in addressing that through the order on reconsideration after that hearing, it would address each of them individually, maybe by one order that is listed for each of the following petitioners. Certainly the board, for example, with some of its orders on reconsideration of water rights fees, for example, does orders that apply to more than one diverter. So there is a number of ways the board could address, as long as it is trying to address everybody's and noticing everybody that if they're getting a evidentiary hearing that they can participate, then, you know, to whom those factors apply, then I think the board can do it in a number of different ways.
And
think about
so on that note, I just have one 30-second point left
go ahead.
that I
This
think
is
kind of
helpful.
plays into this really well. In thinking about this, one of the things that I looked at was the 76-77 dry year report, and I was very impressed with the approach that they took. It had a lot of similarities to this year. It was really dry. One of the differences is that in that water year, the water board got 212 complaints. I think obviously from where we're sitting, we're expecting potential complaints, and my understanding is we haven't gotten, or the State Water Board has not received any specific complaints yet. 212 is a huge number. They whittled that down and worked with stakeholders and ended up doing 30 hearings that year. And one of the ways they did that was they shortened the hearing request time to 15 days. They specifically looked at evidence and made evidentiary rules and allocations to make the hearings work faster. So I think there's a lot of thinking outside the box. I would definitely warn the Water Board against doing this kind of post hoc petition for reconsideration concept, and look more to this idea that they did in 76-77 that allowed them to process over 200 complaints, of speeding up the due process that we're all comfortable with and we know and recognize. So certainly I would recommend, if we're going to do this, to taking that approach.
Thank you.
Thanks so much.
Thank you.
Just to clarify, we do have complaints. We have about 50 complaints on the books right now. They're not all necessarily drought-related complaints. Many of them are public trust complaints that are related to drought, but there are also water right-related complaints as well. So,
And how does that compare to, say, a year ago, 2013?
I think it's about triple what we usually see.
Okay.
And it'd be helpful, just as a note, it'd be helpful to, I think there's been so much talk about that. It'd be really helpful to either post those or to put a link on there. That would really diffuse the conversation. I know I've had so many conversations about where are these complaints? Why are we doing this? No one's going. That comment has come up so many times today. To just say, yeah, we've got 20 drought-related complaints. Here they are. Here's the link to it. It would make everyone quiet down on that, and then we could look at it and look to see if there's other ways we can work with the Water Board to do this right. Thanks.
Thank you, Ms. Kincaid. Dan Kelly, followed by Dov Gallery.
Chair
Dan
Marcus of
Gallery,
Board-
sorry.
Chair Marcus, board members, thank you. I want to first say thank you. I think there have been some really good questions back and forth. I think the board members have all asked some really thoughtful questions of staff and of the participants. It's really nice to see these issues kind of get, some of the more important issues get teased out and talked a little bit. I think it helps develop a better record and give better understanding from the regulated community about what you all expect and what we all can expect from regulations should they be adopted. So I'm here to, I guess, express in one part a little bit of frustration, and then I have two questions. My frustration is, and I'm here on behalf of the Byron Bethany Irrigation District. They've got pre-14 rights for water and irrigate quite a bit of land, and they've been incredibly proactive with their water users about the likelihood of curtailments. And they've been warning growers since mid-March that they were going to get curtailed, notwithstanding the fact they've got pre-1914 rights. And they get updates. They get updates, letter updates, probably twice a month. Every time the board issues an agenda with possible curtailments, they get a notice. And any other time we get correspondence from the board that suggests a curtailment date, they get notification of it. The staff of the district go out regularly, and if they see folks out there plowing ground and starting to plant, they stop and they warn them, you're going to get curtailed. And part of the frustration for my board is we were told we were going to get curtailed on June 1, June 15th, June 23rd, and now we thought we were going to get curtailed July 1. And so what you've got now is you've got a district with some senior water rights and growers that have been dying to start planting, and they've been warned that they're going to get curtailed, and they've not planted because they were afraid curtailments were coming, and now it keeps getting pushed back. And the message I heard today, again, is just because these regulations get adopted doesn't mean we're going to see curtailments of pre-1914 rights. And so I'm going to suggest that the really hard work isn't developing these regulations and creating these alternate due process methods. The really hard work is to find out when these growers are going to get cut off and let them know now. You either are going to get cut off in early July, or it looks like you're going to be good until early September. Surely we've got to be able to make some kind of estimate with some confidence, so we can go back and we can tell people we have an 80% confidence that you're going to be able to divert until August 15th. And then they can decide whether or not to assume the risk, the 20% chance they're going to get cut off. But just kicking the can down the road isn't doing anybody any favors. And so the frustration I'm expressing is that we provided, or that growers be provided some kind of certainty about whether or not curtailments are going to happen to pre-1914 rights. Very quickly, the local agreement provision in 878.3, I simply don't understand it. I asked the question, I think we talked about this when the board considered the regulations for the 3 creeks in Tehama County. And I expressed concern then that I thought it kind of subverted the priority system. It still seems to me that that's what it does, but I'm not sure. And so I think some clarity on what that section is supposed to do would be very helpful. Is it simply to encourage local transfers, to provide an expedited method for people with alternate rights of water to share amongst themselves? Or is it really just to provide people an exception to curtailments and, notwithstanding their junior status, allow them to divert? I mean, people really need to know that. So I can't imagine where an exception to curtailments would work without injuring other legal users of water, because somebody else has to stop diverting for there to be water available for junior people to divert. And so a little bit of clarity on that would be very helpful. And the last is the health and safety exception. There's been a lot of talk about it. It's not included in the current draft of the regulations. Byron Bethany Irrigation District is a wholesaler of water to the community of Mountain House. It's a community of 13,000 people. Sole source of water is BBID. If we get cut off pre-14, they get cut off. There's no groundwater there. They're not connected to any other system. We're it. And so it's important, and it's going to be important, especially to Mountain House. And BBID is doing everything it can to try to help find an alternate source of water for Mountain House. So, you know, when the time comes to get water cut off, they only get water if we pump the water. I guess if we pump the water, we subject ourselves to the enforcement action, even though we're only pumping the water to get it to Mountain House. And so I think that we need some clarity on what is the 50 gallons per person per day supposed to cover. Mountain House has 12 or 13,000 residents, but they've got 4 or 5 schools, they've got businesses, you know, and so is there water that's going to be available? If that exception gets put into the regulations, is there going to be water available for schools as well as 50 gallons per person per day? How much water for fire suppression? Obviously, that community has a significant fire suppression system. BBID provides fire suppression water to the Contra Costa Airport. We're the sole source of fire suppression water for Contra Costa Airport. And so, you know, but we don't use it. We just provide it to these third parties. And so I think it's going to be important to let folks like BBID know if they've got to provide health and safety water to third parties, are we exposing ourselves to enforcement action, to $2,500 an acre foot, to $10,000 a day, or whatever? So
No, that's precisely why we asked for comment on the exception.
So, and again, I'm not sure if that's going to be put in there, but if it is, I think those are some questions that I think could probably use an answer to.
Yeah, we unpacked it just because in the last workshop we were talking about too many things at once, and so it was very hard to get a clear, focused response. This way, we're focusing on the enforcement mechanism. People are spending a lot of time talking about the method of curtailment, pre-14, post-14, et cetera. We're all happy to hear, but the purpose of this was the enforcement mechanism. It's not that they're separated. And then we asked for comment on health and safety so that we could unpack each of these very complex issues and make the decisions in a way that folks could have sort of one conversation about what it was we were trying to do, imperfect though it may be.
Okay, thank you.
So, thank you. Dan Gallery is our last speaker.
Thank you, Madam Chair. Dan Gallery. I just have a follow-up, actually, on this last question asked by Mr. Kelly. I was trying to get an interpretation of the subsection C that says that under the minimum health and safety needs, diversions for domestic municipal use under any valid basis of right of less than 50 gallons per day is going to be acceptable. That goes on to say 50 gallons per person per day, not exceeding 10 acre-feet per year of storage, or a 4,500 gallon per day of direct diversion may continue. And what that means to me is that any water supplier can provide up to 4,500 gallons per day, but no more. And not to exceed 50 gallons per person, but total not to exceed 4,500 gallons. What that means to me that a water supplier can supply to 90 people with 50 gallons per day, but is that the end? Now, this preceding gentleman, he's got a whole community that we provide domestic water, and so I was troubled by that 4,500 gallon per day as limiting a water supplier or company to not provide any more. I wouldn't think it means that, but that's what it says. I have
Can I ask a question? Staff, do you want to clarify what you meant there, or the intention of
Yeah,
that?
absolutely.
We've actually not talked about health and safety anywhere near as much today as I thought we would, but.
No, I'm excited to talk about it. So we're pointing at C as on the current proposed regulation, with C being what was formerly B for those following along at home. But C1, which is what Mr. Gallery is pointing to, specifies what is essentially a de minimis process. So if these minimum health and safety diversions are within the limitations identified in this section, so less than 50 gallons per person per day, and under a total diversion amount as specified in here, these are the same diversion and storage numbers in our registration program, that's where they were taken from, then they can self-certify that they will comply with the conditions of this section. If somebody is diverting over those cap amounts, the 10 acre-feet per storage or 4,500 gallons per day of direct diversion, then they go through the petition process like anybody else, like ISO electric needs or air quality needs or more than 50 gallons per person per day. All of those, anybody requesting that go through the petition process to the deputy director. So really the distinction is not what's available to the end user, but what process they go through to get that. Does that make sense?
All right, sorry, if you continue.
If a community needs 6,000 acre-feet per day, they've got to go through the petition process rather than having an automatic.
That's correct. If somebody needs more than 10 acre-feet of storage or 4,500 gallons per person or 4,500 gallons per day of direct diversion, then they go through the petition process.
I was going to suggest in this particular case, the small mountain community that I represent, they have maybe they have 60 people during the week, but in maybe 120 people during the weekend. You have a provision when you issue a permit for 4,500 gallons per day. You have the code says, and you say that's the maximum allowance for any 30-day period. And in that case, you can divert more than your 50 gallons per day part of the month. But as long as you don't use more than 4,500 for the total month per day, then you're okay. And I'd suggest you add that to that 4,500 here. That would help some folks that would be able to get that exemption without having to go through the petition process. Thank you. That's all I had.
Okay, thank you. All right. We've heard a lot of concerns. I appreciate you all staying this long as we think it through. I do think there are a fair number of questions, just judging from the questions or discussion that I and my colleagues have had. I don't know, or at least I don't feel comfortable deciding something tonight without more discussion and thought. We could come back to this tomorrow, but I would like to, I know it's late for some people, but I do think I'd like to hear from my colleagues, what are the key thoughts that you have, anything you'd like staff to answer, anything you'd like staff to think about, and how you'd like to proceed, even just impressions, so that we can even figure out how to proceed from here. I think a lot of questions have been raised. I know there are also a lot of old battles that have been raised here, and I'm not saying those aren't important old battles. They're battles. We're not going to resolve every issue between every party and everything having to do with California water law and its implementation in this particular decision. However, people have raised some very interesting and important points that I want to make sure we give the appropriate amount of thought as we consider whether or not, or how to, if so, adopt anything, these emergency regulations or anything like these emergency regulations. And to the extent we can have a preliminary conversation now, I think it will help figure out how to give direction to staff one way or another, but hopefully for constructive thought, game plan, etc. Because I'm not quite sure what, if I had to recommend something right now, I would want to be asking a lot more questions and asking for some things.
Mm-hmm.
So, who wants to go first? Anyone?
Okay.
Well, I think the TAM asks staff to think about intermediary steps. Have you given that some thought? Because I'd like to hear what how you interpreted that question based on what you've heard.
Sure.
Wouldn't it be intermediate?
Yes, I liked intermediary.
I did too, but I'm not sure it's the right word.
Steps between the adoption of the regulation and approval of the regulation, should that occur, and when an actual curtailment decision / orders are actually issued. Order.
And I would combine
And I would, I'm sorry, and I would envision such intermediary steps to include what Member Moore talked about in terms of presenting information of, this is what, a combination of what Mr. O'Loughlin and Member Moore talked about in terms of, this is the information we reviewed, this is the preliminary determination we've made. Do you have better data before we go forward and take action?
So I think what's been a great communication tool is our website, though I think now putting more of that detailed information prior to a curtailment order. So we've had those supply and demand charts, but it really could have more of the information that I was describing before we do a curtailment order. Well, this is everything that we've got upon which we would be basing the curtailment order. And that could be done at some point. We can do it in real time as we're developing that information, because I think it's also good, we've heard, to provide a heads up as to where you're going, although with the follow-through, we've also heard not to just keep pushing it out, but we put that information out there, everything that we have upon which a curtailment would be based, and then I don't think we've thought through yet the timing and how much additional notice, if you will, if we have a notice that's saying, well, this is a notice of a curtailment order to be issued in some period of time, and this is an opportunity to more informally provide information on what's missing or what else you might like to add. Some of this timing is problematic because if we're there where it's already an imminent curtailment is needed, how much time do we have? So I think we'd have to think through case by case how much time is allowed there.
Yeah, and when I said notice, I didn't really intimate it has to be a formal notice. I was more that it's almost, it's like in the discharge permits we do tentative orders. Or you could just do a draft order, but just some kind of, if the process needs to be telescoped in order to protect senior water rights holders from diversions that would injure them, there has to be a timely review process. So
it would be a little bit more of that formal information that we've been hearing, that the meetings that have been had with Mr. John O'Hagan and staff have been helpful, but it's like putting all of that out there, and it looks like this all seems to add up to a curtailment, and add perhaps a little bit more formality to, if you have any other information that shows why this is wrong or needs to be adjusted, but this seems to be the information that we'd be, or is the information that we'd be using upon which a curtailment order is imminently going to be issued. So that would add both the transparency of the information and a little bit more process.
And how would you prioritize the workload in determining when curtailments might be necessary? Is it based on complaints that are coming in? I mean, what is the prioritization process?
I think we've also heard that. If we haven't been sharing that information where we have complaints, that would be part of the package. Well, and we have a number of complaints in this area, and I think then you know, I would hate to see it as a very formal process that this is exactly what we're going to do, but if we have the information, for example, that, well, full natural flows are going very close to zero or very low in these areas, and we have real-time gauge information that is showing there's also very little flow in the system. And by the way, we now have 2 or 3 complaints in this area saying, I think I should be getting water, and they have a senior water right. That would add up to the information, the seed of a curtailment for that area, for that class. So it's a packaging of that information and a transparent posting of that information.
Right, in a geographically relevant way, so that people can understand who it is we're worried about protecting, or what water.
Well, and that I think that would be the linkage that the complaints, that if it's like, well, if it's a complaint associated with why am I not getting the water that I feel that I'm entitled to?
Yeah, I'm not sure. I think we can see if someone's going to be hurt, and you would check. I don't know that I would require that folks have to complain against their colleagues. I'm not sure about that. I think that's an issue. The other issue that folks have raised is not just that you might post, there different things have been raised. One is that if the deputy director is making decisions showing the basis for the decision and all of the underpinnings, you've talked about doing it on the website. Mr. O'Loughlin and others suggested being able to do some sort of a hearing here where there's a chance to ask questions and show the data. All of those seem like viable options to consider to put more data out there, rather than right now the way it's written, where we may feel comfortable that we wouldn't be curtailing unless, or that you all wouldn't be recommending curtailments or issuing curtailments if it weren't necessary. The issue of transparency and people understanding the basis for it seems really important, even in a petition process. It seems the issue is, if we were going to do a petition process, you would want to have some assurance that there's going to be some transparency and some opportunity to understand and challenge the basis for that. And obviously people have 2 different grounds for challenging curtailment. One is going to be the hydrology, and the other is you don't have my right.
Right. Several points on that. One, I think that in as much as complaints don't actually themselves establish a basis for curtailment, it's the underlying substance that's in the complaint that assists, and that's what we're trying to gather already. What we already have, and I'm not sure everybody is aware of the breadth of what's on our curtailment website, is, I think we had talked about this in the presentation, there are projections as to, at least in certain watersheds, when water will likely not be available for certain classes. I think that we could improve that with all the information we have and make it more robust. But the other point that you raised, so that people have a clear sense of what a curtailment order is based on, the change sheet that we had already put forward, that says summary, and I think Mr. O'Loughlin had proposed some different language that was more specific, but something along those lines.
I would definitely want something more specific than that.
We've already proposed something and can take that language or modify it to do exactly what you're suggesting, be more specific. But that's another opportunity to ensure that when people actually get a curtailment order, they know exactly what it's based on, coupled with information on our website that's already there and could be improved upon. We put more things there, complaints, then people would know what's coming. One additional point I wanted to note is there isn't a curtailment notice process under the emergency regulation, but that doesn't wash away the fact that many people have already received curtailment notices, either generically, we sent statewide